So, without further ado, let me introduce you to Chairman Frank McKay. As you know, he was appointed several years ago by Governor Deal. He came to the board from his private practice in Gainesville, Georgia, where he handled several workers' compensation claims. He handled them all the way up to the Court of Appeals. He's also a former Special Assistant Attorney General. He was handling workers' compensation claims for the state of Georgia. He's a graduate of Mercer University Law School. Undergraduate was Clemson, which he does wear very proudly. And he was on the State Board's Advisory Council, I believe, prior to being appointed the chairman. So please welcome me and or help me welcome Judge McKay, or Chairman McKay to speak to us. Thank you.
You know, workers' compensation kind of is like a family, and it's not so big within the state of Georgia that a lot of lines kind of cross over. I mean, you get to meet a lot of people at a conference like this or another conference, and it's really good because a lot of whether you're working with a TPA or an insurance company or one of our group funds or the state of Georgia or the DOES or any number of ways, and I see a lot of people in the room that have kind of transitioned and changed over the years. I was just curious how many people are here today for your first time to come to this particular conference. So there are some hands, and by far most people have been at this conference before. So I have another hand-raising question, and this kind of gets into where we are at the state board. How many of you have undergone the state board's training to be able to access ICMS and file a board form and actually go in and access your file with the board and file the first report of injury, WC2, notice of controversy, WC3, or anything else? So I see some hands, but not the majority. So that's a good example of the feedback that I would like to get, Rodney, on how that's going, because we've had over 800 people have gone through the board's training to be able to access our ICMS filing system, and you can electronically access your claim file on your claim that you're working on, that you're handling, that's at the state board. And you can see what's been filed in that case, what board forms have been filed, what did the injured worker, the employee, what did they file, what were they seeking when they filed a request for a hearing, and then what's been filed, has your first report of injury been filed? And that's one of the big updates that we had that went into effect January 1 of this year, and I hope that's going well, but the requirement to actually comply with a long time existing statute to require the filing of a first report of injury for every injury. And that's medical only claims as well as the lost time. You know, traditionally, we only enforced the lost time part, but now enforcing the medical only claim and filing the WC1. Very, very important. And I'm glad to report that the number, it looks like that's being complied with very, very, very broadly, very well across the board, because the tremendous increase in the number of WC1s, first reports of injury filed with the board to pick up the medical only claim. So I'm here to thank you for that, and I hope that is going well. Of course, that can be done through your EDI vendor, your EDI filing. It can also be done for those that raise their hand that have gone through the training and can access the board's ICMS filing system. And so that's been a very, very strong plus, and that's a huge development there. The proper filing of board forms, and most all of you do an outstanding job, because we see a lot of cases. So we're always looking in our board file to see, are the forms that are required to be filed, have they been filed? First report of injury, which may or may not commence benefits, as you know. Sometimes it's just the initial report of injury, and it may be on a medical only claim, and then later a WC2 may be filed to commence the benefits, and then maybe another WC2 file to suspend the benefits or to convert weekly temporary total disability benefits to something else, like temporary partial disability benefits or permanent partial disability benefits, and reflect that. You know, the whole purpose for the board forms is so that the board and employer and the employee and our judges that are working on a case can look at that file and tell exactly what has been done. And the benefits should sort of tell a story. It should all be there with the board forms. If they're filled out correctly, it should tell you how much the benefits are on a weekly basis, what the date was when they were commenced, and when they were suspended, and when they were recommenced, when they were suspended again, and when they were converted, and all of that should be there. And in most cases it is, but every now and then we'll see a case where it's not. We saw a case recently, and it had to do with the in the EDI world, the SROI, the subsequent report of injury, and in our world, the WC2 filing that. And I think this is a good reason to come to these seminars, to help learn and reinforce form filing and how that's to be done correctly. And somebody was trying to do it correctly. They were trying to fill out and file a WC2, and they were trying to suspend benefits based on a release to return to regular duty work while the employee was out drawing weekly temporary total disability benefits. So I'm sure everyone in this room knows that, well, that requires a filing of a WC2 to unilaterally suspend based on the authorized treating physician's report of a release to return to regular duty work. And the WC2 form has those boxes to check in the section C, what the date that you're suspending and what the date of the medical release was. And it requires that actual medical release be attached to the WC2 or also filed in our ICMS system. And if you have access to ICMS, you can do it that way. You can attach it. If you're strictly EDI, then the board rule requires that form be mailed to the board with the attached medical record. And so there was the individual handling that claim was trying to do it right. They filed a 2, but they didn't do it right, and they filed another 2 trying to do it right. They still didn't do it right. They didn't get the right boxes checked. Didn't have the dates in there, didn't have the reason that they were being suspended, didn't attach the medical report to it. And so that's problematic. And that's just we see that from time to time. Fortunately, that's on the rarer side than not. And I think all of you are very, very good about understanding what those board forms are for, what their purpose is, and how they're to be used and to be filed and utilized. So we appreciate that very much. I was very glad to see that Judge Drew is here. She had court this morning. You just never know when you go into a hearing how long the hearing's going to last. We had a hearing board not too long ago, it was this year, that went until 11 o'clock at night. It started at 9:30 and it went all day until 11 o'clock at night. So I'm glad that Judge Drew's today, she had one this morning, it wasn't going until 11 o'clock. She's here to talk about and give you an update on the petition for medical treatment form. And she'll talk about the numbers and how that has worked. And we certainly welcome feedback on that. But the entire process went into effect July 1, 2017, and has been highly successful. Basically, it has a 100% success rate in accomplishing the stated goal, and she will talk about that later. It looks like a really good program, Rodney, today. Very relevant topics from the report on the petition for medical treatment, and along with the case law update. I think that's an area of workers' compensation that's fascinating, or the case law updates. You always have cases, you always have changes in the law every year. And that what keeps our jobs very, very interesting, whether it's a legislative change in the law from the legislature or a case law change by the Georgia Court of Appeals or the Georgia Supreme Court. One of the cases this year that came out last year, and another case following on it this year, was the Fret versus State Farm. It has to do with the rest break or the lunch break cases, dates of injury, time of injury that arises during a regularly scheduled break. And it's really surprising to me how many cases we have yearly that fall in that narrow window of time at work, but during a regularly scheduled break. And I won't talk too much about the case because I'm sure that was going to be talked about in the case law update. But one of the things that was very interesting about Georgia's law on that, because all states are different. That's another fascinating area of the workers' compensation law. Georgia recognizes the regularly scheduled break defense, and not all states do. And in Georgia, we had this, it was kind of a murky area of law in trying to decide which breaks are subjected to the defense. Does it have to be a regularly scheduled break, or can it be a break at any time during the day, but it ends up being so-called scheduled? And then the courts, over the years, it kind of merged the ingress and egress rule to, does that apply just at the start of a workday and the end of a workday, or does that also apply at the start of a regularly scheduled break and the end of a scheduled break? And the court made that very clear, and I won't give the punchline away of that. That will be talked about. But the case is very interesting because we had this diverging line of cases in our Court of Appeals, and this FRET decision was a full court decision. All the judges that were currently on the Court of Appeals participated in this decision. So it makes it binding precedence. And they went back and they cited a 1935 case. The reason they went back and cited a 1935 case was because that was a case from the Georgia Supreme Court. So the Workers' Comp Act was enacted in Georgia in 1920. So next year we're going to have our centennial, 100 years of our Workers' Compensation Act in Georgia. We'll definitely have to celebrate that, recognize that. But in 1935, just 15 years after the Workers' Compensation Act was enacted, the Supreme Court of Georgia issued a decision on a break case. And it involved a maintenance worker who was working in the basement of a building working on the boiler. And he was working on doing repairing and fixing the boiler, and it became time for his lunch. And so he went upstairs to the first floor, to the bathroom, to wash his hands, and was coming back down the stairs to eat his lunch, and he fell and he got hurt. And the Supreme Court in 1935 said, well, that's not a compensable workers' compensation case, because that didn't happen when he was actually doing some work. That was for a reason that was very personal in nature, to have actual eat lunch. So that was his own individual affair. Well, we've had cases since then that sort of broadened that and said, well, wait a minute, some of these things that happen at work are covered. But the fascinating case, so I'm sure they'll talk about, is that this 1935 case was a Supreme Court of Georgia case, which takes precedence over the Georgia Court of Appeals. So it's a decision from the Supreme Court is the highest court in Georgia. And so the Court of Appeals, in this full panel discussion, which now we have 15 judges on the Court of Appeals, participated in this decision. And they cited the Supreme Court case because all these other cases over the years, from the 1940s, the 1950s, 60s, 70s, 80s, and 90s up to the present, and talking about breaks and whether they're regularly scheduled or not, they were all Court of Appeals cases. And this FRET versus State Farm case went back and said, if anybody's going to change the law, we recognize that we, as the Court of Appeals, have had two different lines of cases where some of these accidents that happen on break are covered, compensable, and some are not for various reasons. That's going to be up to the Supreme Court of Georgia. That's sort of reaffirming the precedence of the importance of Supreme Court of Georgia cases and prior precedent cases. And that's ended up what they said. It's either the Supreme Court or the legislature would be up to them to change the law in this area. So it's really one of the fascinating areas of our workers' compensation law on that. I saw on the agenda, the other area today that's very relevant is your medical panel discussion. And of course, we all know that the opioid crisis in the nation and in Georgia as a whole is certainly evident in our workers' compensation system. And we see far too many cases at the state board where an injured worker has been on high doses of opioids and a high level of morphine equivalent dose per day for years, sometimes 10 years. Tremendous issues with the return to work issue. You're going to talk about that later today. Some of these issues involved in returning to work, and this is one issue that we see that's a very troubling area. And these alternative ways, I think within the medical community, and I'm sure the medical panel is going to talk about that. I mean, recognizing that prescribing habits or what became accepted practice in the 1990s has definitely changed, recognizing the addictive nature of opioid narcotics and how the severe impact on not just the injured worker, but their spouse, their family, their employer, with return to work issues and quality of life. That impact have been impacted by high level and long-term use of very addictive types of medications. So there's lots of discussion going on at the board and within our medical community and in the workers' compensation system about the alternative types of treatment, whether it's coming out from the CDC recommending changing prescribing guidelines to how that's actually put into place in the practice. So that's another area. And those cases certainly always deserve a second look when you're working on those cases where you've got long-term opioid use and prescribing patterns as to what can be done here, what can be done to help this individual get off this cycle of addiction, and maybe it's a return to work issue or a rehabilitation type of issue, the various alternative types of treatment that are available and being offered. So that's kind of an update from the board. I've just got a few minutes, so I will wrap up here and want to thank you for the good job that you do, because we see it day to day as we're looking in the board forms, the files that you're handling, that we see. Most of the cases that are filed with us, they don't end up in litigation. It's probably only about 15 to 14% of the cases that are filed on an annual basis that actually end up in litigation. And therefore, they consume about 80% of the time, just like I'm sure a handful of your cases take up a lot more of your time than most of your cases that you work on. But you really do a good job, and it's very meaningful work. It's very challenging, and it's not void of stress, certainly at times. But you do a great job in handling the cases of the injured workforce in Georgia. We had about 135,000 reported accidents last year in the state of Georgia. Most of those were medical only, not lost time, but about 28,000 were lost times, a bit more severe of an injury, invoking lost time. But you do a great job in handling those types of cases. And of course, we see everything from the worst case possible, a fatality or a severe catastrophic injury, all the way down to just a minor first aid type treatment, and that's it. And it runs the gamut, so it makes it a very, very, very interesting area. I'm going to stop there, turn it back over to Rodney. Next week is first week of July, and next Thursday is the 4th of July, so I wish all of you a happy 4th of July, and hope you have a good week next week. I hope you have at least the 4th off, and maybe take Friday off too. So thank you.
Thank you, sir.